I call Charles Chevelle.
Thank you, Mr Chairman. Mr Chairman, I want to just rise and make a couple of points about Part 1 of the legislation bill. The purposes of the bill are set out in Clause 3. The first is that the new Act should bring together the main provisions of New Zealand legislation relating to the drafting, publication and reprinting of legislation and the disallowance of instruments. The other purposes include providing for electronic and printed copies of acts and legislative instruments to be published, to provide for official versions of acts and legislative instruments to be published in electronic form. At the moment, the only authoritative form is the written form. To facilitate the production of up-to-date reprints that are modernised and made consistent with current drafting practice concerning their mode of expression, style and format. The next purpose is a very significant one because it relates to accessibility. This is a principle that the Regulations Review Committee has stressed the importance of a number of times, and the bill expressly sets out to make New Zealand statute law more accessible, more readable, more easy to understand, and it sets out to do so by the means of facilitating a progressive and systematic revision of the New Zealand statute book so that statute law is to be rationalised and arranged more logically, inconsistencies and overlaps will be removed, obsolete and redundant provisions will be repealed, and expression, style and format will be more modernised and made more consistent. The other two important purposes of the legislation, sir, are to enable certain kinds of subordinate legislation to incorporate material by reference and reliance on the statute, subject to compliance with consultation and other requirements. Members will know that the phenomenon of incorporation of legislation or material by reference into our law is an increasingly common phenomenon, particularly as we adopt international legal standard. It's not uncommon for legislation these days to refer to treaty provisions which are extraneous to the statute itself, not necessarily even scheduled to the statute as used to be the practice. There's often a reference in the schedule to where the provisions of the statute can be, of the treaty can be found. So it is important that we are clear about how material incorporated by reference into the laws of the land is able to be found by the reader so that the reader may ascertain on any occasion what the law of the land is. Finally, sir, the legislation will replace an Act of Parliament that is many, many years old, the Statutes Drafting and Compilation Act 1920, and it will replace it with modern legislation that continues the office of Parliamentary Counsel, but as a separate statutory office that facilitates the drafting and publishing of high-quality legislation. Now, those are all purposes with which the opposition wishes to associate itself. Listeners to the debate might be wondering, well, why is this set of aims necessary? What's wrong with the status quo? And perhaps what they might like to think about is the way in which statutes are published and accessible at the moment. When they are published, Acts of Parliament are ordered chronologically, which means that the user looking for an act on a particular topic is likely to have trouble knowing exactly where to look for it unless they have an index or unless they're searching on the internet for electronic copies of the legislation. The law on any one particular topic can be scattered through an entire range of acts. All of the content of an act may not be indicated by its title. Provisions about certain matters can be located in all sorts of unlikely or unexpected acts unless the reader or the searcher has a degree of legal training and knows, because of that training, where to look. Sometimes it might be quite a surprise to find particular provisions where they are actually located. Amending acts sometimes contain substantive provisions which stand separately from the act being amended, and these can be easily missed when searching for provisions on a particular subject. Obviously, some acts are old, Mr Chairman, drafted in archaic language that's difficult to understand, or drafted in a style that, because it's not compatible with contemporary usage, just isn't accessible to the reader today. Acts can be amended several times before they are replaced, and this can mean that there are inconsistencies in drafting style between the original and the inserted provisions in the same Act. In addition, redundant and obsolete provisions can remain in force. And while the Parliamentary Council Office is responsible for publishing Acts of Parliament, it does not have an express function relating to the presentation or accessibility of public acts. When formulating policy, government departments don't always treat accessibility of statute law as a priority. So, Sir, I'm hopeful, given the aims of the legislation, that those are some of the problems that we currently face in accessing our statute law that will be remedied by this bill. Certainly that was the hope that was expressed by a number of submitters to the Regulations Review Committee, and the committee's done its best to ensure that in reporting a draft of the bill back to the House, the principles that I've listed will be preserved as we enact the legislation. So just a word about the background to the bill. It will implement the majority of the legislative recommendations made in two Law Commission reports. First, the presentation of the New Zealand statute law dating back to October 2008, that's NZLC R104, and review of the Statutes Drafting and Compilation Act 1920 from May 2009, NZLC R107. Sir, many of the problems that I listed earlier are identified in those reports, and the Act is an attempt to address a number of them. The Minister has tabled, I see, a 27-page supplementary order paper, and it would be, I think, helpful to know, while we've had a chance to read the supplementary order paper, at least cursorily, whether the supplementary order paper makes any substantive changes to the aims of the legislation and the purposes of the Act. Obviously, it would be helpful if that were the case for him to address any of those changes so that the House is clear in committee as to what we are doing as far as recommendations that might differ from the reported back version from the committee. And Sir, perhaps also just a word about the legislative history here. The bill was considered by the Regulations Review Committee of the previous Parliament. The Deputy Chair, I think, is from the committee is present in the House. There was, I think, at one point a proposal from the Attorney General that this legislation should be combined with the Regulatory Standards Bill. And apparently that does explain some of the delay in bringing the legislation back to the House. I think the Attorney General would agree that it was considered not proper to combine this legislation with the regulatory standards legislation, given that the latter bill doesn't have wide support across the Parliament, whereas, as my understanding is concerned, this legislation bill does have that support, and so it's been decided to now bring this bill forward in its current form back from the Select Committee with the reasonably substantial supplementary order paper that I mentioned. And I think that is, if my understanding is correct, if the Minister and the Chair can confirm that, then certainly that's a move and an approach that the opposition would support. This legislation is good technical remedial legislation. It wouldn't have been appropriate to combine it with legislation that advances a particularly partisan agenda from the ACT Party, as the Regulatory Standards Bill is intended to do. Sir, with those few words of introduction on Part 1, I certainly look forward to and anticipate the rest of the debate.
Mr. Chairman.
The Honourable Phil Goff.
Mr. Chairman, this is an important piece of legislation and a very